Hey guys, in this video, we're going to talk about what you should do if your marriage green card case is denied. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where we believe in freedom. Type in freedom now if you also believe in immigration freedom. We're reachable at McBean Law at 914-898-9488. Also, guys, before you go today, don't forget to subscribe to this channel and hit that notification bell so that you'll be the first to get notice of these videos each week. Now let's get into it. Getting a denial from immigration is a very scary thing, particularly today, where we see that USCIS is very serious about their new policy, the NTA policy, which says that if they deny a green card case, they can place an individual in removal, specifically in the marriage context. If your marriage case is denied, USCIS has said that if they find fraud on the record or a criminal issue, they will issue a notice to appear and place you in deportation court in removal proceedings. Nowadays, USCIS is also tweeting some very inflammatory language saying that if we deny any case, including a work permit, an asylum, or a green card case, we will place you in removal proceedings, which is quite ridiculous because that's not what the law says. Let's get into what you should do if your green card case has been denied. First of all, what was denied? Was it the I-130 petition for your spouse, your petitioner, U.S. citizen or green card holder spouse? Was that denied? Or was it your adjustment of status green card application, the form I-485, that was denied? It is possible, friends, for the I-130 to be approved and the I-485 to be denied. Why? Because the government believed that the marriage is genuine, it's bona fide, so they approve your I-130. However, there was some doubt that came up regarding your immigration history or a criminal matter or fraud or misrepresentation or something on the inadmissibility side that caused them to deny the I-485 application. And if you can cure the problem on the I-485 side of things, then you will be able to finish the process successfully with a green card. Was it the work permit, the I-765 application that was denied? Or perhaps was it a travel document, the form I-131 that was denied? Get clarity on what specifically was denied by the government. It's even possible that your work permit could be denied and yet they go ahead and approve your green card application. So get the clarity that you need first of all to find out what was denied. Now, if everything was denied, the I-130, the I-45, the work permit, the travel document, everything was denied, well, there was a big problem with the filing and you should immediately seek legal counsel or legal advice about what your next steps are. Your next steps will really depend on this question. What is your spouse's response to the denial? And the spouse that I'm referring to here, friends, is the U.S. citizen or green card holder petitioner spouse. Is he or she still supportive and committed to seeing you all the way through till the end? Are they willing to try again or fight harder for your case? Are they committed to you and the marriage? Because, friends, if they are not committed to you and the marriage, well, this green card process, which has already been slowed down by this denial, will become even more complex. Is your spouse emotionally checked out? I've met with people over the years who've said things to me like, we tried a couple of times with immigration and it just didn't work, and now my husband or my wife, he or she has given up. They don't want to have anything further to do with the case, and I'm so frustrated because I feel so stuck, yet I'm in this marriage, I love my spouse, but he or she is emotionally drained. If that's the case, friends, an immigration attorney can help your spouse understand what his or her responsibility and role is in this process and what's expected of him or her, and really identify what the problem was with the first filing so that the spouse can realize that maybe there's a way that we can do this in a way that I would not have to be so stressed out, right? If you think your spouse is reasonable and will actually listen to ideas or another perspective, a fresh perspective by an immigration attorney about what to expect, well, ensure that you have that conversation with an attorney. However, if your spouse is considering a a divorce or if a divorce has already been filed, well, your way forward will look very differently from the couple who is still together and very much committed to seeing this process all the way until the end. If you're in the process of a divorce or if you've already been divorced, you'll have to convince the government that you were in a genuine marriage, but you were abused in this marriage. Or depending on your case, if this is an I-751 removal of conditions green card case, you could even make an argument that you entered into a genuine marriage, but it ended in divorce. Now let's look at why the case was denied. Most commonly, marriage cases are denied based on the couple missing an interview. That's right, because when it comes down to interview date, sometimes the petitioner's spouse will back out, or you guys have an argument and then he or she doesn't go with you, or maybe you both decide that you're just not ready to proceed with an interview, or if you're afraid of what's going on nowadays with USCIS setting some people up for an arrest at their office, you just decide, I'm not going to this interview. And so therefore, if you miss the interview, USCIS will deny your case and say something to you like you've abandoned your case, which is the reason why we decided to deny your case. Another common reason for a case being denied is lack of bona fide evidence to prove that you're in a good marriage, a genuine marriage. You weren't able to prove it. You didn't have convincing packet of evidence to prove to the government that this is bona fide. Or perhaps during your interview with USCIS, there were some flags raised because of some inconsistent answers to the questions, and therefore immigration wanted to drill down further with you and asked you for more evidence to prove a bona fide marriage, and you were unable to come up with the evidence. And this ties right into having a bad interview. For some couples, one of you freezes, right? You get in there and you just freeze because of how fearful you are of the questions that are being thrown your way, and you know how very important this is and you don't want to mess it up, and so you become flustered and you forget some basic information, and it raises a huge flag with immigration. And so therefore they deny your case based on inconsistent responses. Another reason why a case would be denied is the government sent a request for evidence and you did not respond to that RFE. But then there are some serious issues that lead to a denial. Number one, fraud allegations. After interviewing you, if there are any flags related to your file, USCIS would call you back in for a second interview known as a Stokes interview and ask you up to 100 questions about your relationship, including how you met, where you met, how the relationship developed, what your marital home life is like together, and just really drill down into a lot of details about your marriage. If they suspect fraud, like a sham marriage, they will refer your case over to the fraud unit for further investigation. For some couples, the fraud unit would actually come out to your home and ask you various questions, or they might even just call you on the telephone, the both of you, and query you into some issues related to your marriage. And you would also receive a notice of intent to deny your case and be given 30 days to respond to the notice. If the government denies your case, saying something as general as, well, we don't believe that you entered into this marriage in good faith, or you didn't provide enough evidence to prove a bona fide marriage, it means that they think that you were part of a sham marriage, that even though they might not come out and say directly that this is a sham marriage, they are actually saying that they believe it is a sham marriage, and they will put this on the record. And with your next filing now, your immigration attorney will need to overcome the issues that they pointed out in the first denial in order for you to be approved the second time around. Second issue that comes up for some couple is the fact that you were not even divorced from your first spouse, maybe back in your home country. You did not have a proper divorce, okay? And therefore you're not legally married and in a valid marriage to this U.S. citizen or green card holder petitioner. And USCIS will investigate the divorce decree to make sure that it is genuine. And if it is not genuine, they will deny your case. Another serious issue that we've seen, of course, is failure to disclose children who were born outside of your marriage. Omitting a child that was conceived through an extramarital affair. That is very common, guys, and the government looks for this. Another reason for denying the case could very well be you weren't able to prove that you entered the United States lawfully and thus eligible for adjustment of status. Now let's talk about if you're still together with your spouse, what you can do. Number one, consult with an immigration attorney. And I'm going to share with you a success story that we posted involving our client who was denied twice for the green card. And then he and his wife came to us and we were able to do another filing for him, and he has his green card today. After facing 2 previous denials by USCIS, our client successfully obtained lawful permanent residency with the help of the McBean law team. His immigration journey began with an adoption from Morocco, but once in the U.S., the government treated the adoption as a guardianship. His adoptive mother attempted to readopt him under U.S. law, but by the time the process was completed, he was over the age of 16 for immigration benefits through adoption, which resulted in a denial that was later upheld by the Board of Immigration Appeals. He later married a U.S. citizen who filed an I-130 petition on his behalf. Unfortunately, that case was also denied after a USCIS interview and a notice of intent to deny annoyed. In 2023, after marrying his current spouse, he came to us to try again. Knowing how complex his history was, our team submitted a FOIA request to the government and carefully reviewed his full immigration background. We prepared a highly detailed adjustment of status package, including over 400 pages of evidence, and filed both the I-130 and I-45 petitions in September of 2023. The couple attended their interview in July 2024, and later that month, USCIS notified them that their case had been approved. This case is a powerful reminder that even after years of setbacks and denials, the right legal strategy and representation can lead to success. For some of you, you might be able to appeal the denial. If there was a legal error that USCIS made in their decision letter, or if you have new facts to convince the government that you are indeed in a bona fide marriage, or new facts to prove that you've cured whatever the problem was that the government had with your case. You could also consider refiling the case if you've missed the appeal deadline, which is only 30 days. Refiling the case can be a very smart strategy. By giving yourself enough time to gather the right evidence and working with the right legal team on your case, you're setting yourself up for potentially a successful outcome with the second filing. Let's drill down a little bit into this issue of whether you should really refile your case. Number one, you should refile the case if your marriage is stronger than it was in the past. And certainly if you have more evidence to show the government to prove your case. You should also refile the case if your spouse is still cooperative and with you and committed in this marriage. You should refile the case if a new filing will offer a cleaner and stronger path for the green card. And then lastly, when you refile the case, certainly consider what the past mistakes were so that you could avoid making those mistakes a second time. Now, what should you do if you're no longer together with your spouse? You may still qualify for an immigration option. Have an attorney review the facts carefully to determine whether you have a VAWA case that you could file based on domestic violence, and do not assume that you're at the end of the road quite yet. Speak with a professional about what happened in the marriage, what happened with the filing, and whether you can in fact proceed on your own. Proceeding on your own can happen in these 3 situations. Number one, through a VAWA case, as I've mentioned, based on abuse or extreme cruelty and emotional stress in your marriage, you can potentially have a VAWA case. Number 2, if you're going through a removal of conditions process, you already have a 2-year green card and now you're trying to get your 10-year green card, you can absolutely do this on your own through the I-751 waiver process. And then number 3, you can do it on your own in the event that your petitioner passed away and you're now a widow or widower. You can do this on your own. But friends, there is a deadline to doing this on your own. You will only get up to 2 years from the death of your spouse in order to do this on your own as a widow or widower. Friends, this is very complex. Every case is different. Every circumstance is different, but I hope that this video has given you some insights into potentially what you can do now that your marriage green card case has been denied. Here at McBean Law, we're here for you. We work on complex marriage cases all the time, including folks who come to us with a denied green card case. Again, you can reach out to us at 914-898-9488 or just go to mcbeanlaw.com/success and read about our success stories. Thanks so much for being with me in this one. I hope you found it helpful, and I will see you in the next one. Bye-bye.